Hi, this is Heather Orr, and this lesson is about doing business and signing contracts. That sounds vague and like a very large umbrella, but I will try to be as specific as possible. Anytime you do business with anyone, whether you're ordering goods or services, hiring an employee, or going into business with somebody, you are forming a contract. Even if you don't reduce that contract to writing, it is still an oral agreement. Granted, enforcing oral agreements can prove difficult because the parties often have different recollections of what that oral agreement is, but it is a binding and enforceable contract nevertheless. So what I'm going to do is I'm going to describe to you some important contracts, and then I'm going to tell you when you need a lawyer's involvement and when you could probably get away without hiring an attorney. And then I'm going to go through the anatomy of a contract. So that you can understand the different pieces of a contract and you can have the language to discuss it with your attorney or another party in the event that you don't have an attorney. So that's the general outline of where we're going here. So contracts where you need an attorney 100% of the time, absolutely do not pass go, will be the biggest mistake of your life. If you are co-owning a business with a person, the contract with that person needs to be in writing, and you need the help of an attorney, and you need to really thoroughly discuss pretty much every aspect of that agreement. I have handled so many business divorces. They can be very expensive. One of them was $300,000. It took 2.5 years. It was as ugly as an actual divorce, all because of a very bad contract signed by my client a decade prior, before the business was big. And then it got big, and suddenly there was a fight, right? I would never go into business with anyone without well thought out, well discussed, thoroughly drafted contract reflecting what both parties understand is going to be the deal. Okay. Contracts where it's less important that you involve an attorney might be you're ordering goods worth $200. You probably don't need a contract. You put in a purchase order. If things go wrong, well, the amount that you lose is still less than you'd pay an attorney. Okay. And everything else that I'm going to describe to you is somewhere in between those two. Those are your far ends of the spectrum. You absolutely have a contract and absolutely don't need to have a contract. And that concept I want you to keep in mind is this. Good written agreements make for good business relationships, much like good fences make for good neighbors. Handshake agreements are ripe for misunderstanding and breach. It is so often the case that the parties actually aren't trying to screw each other over, but they simply had different understandings of what the deal was. This happens all the time. It happens in almost every dispute about a contract that wasn't ever written or didn't involve a lawyer. I thought we were agreeing to this. I thought this. Well, here's why I thought this, and it's a mess, right? What you want to do is you want to analyze each business relationship in terms of risk. How much money might you lose? Not just the money that you are paying someone else or the money you're supposed to receive, but also the damage they can do to your reputation, the damage they might be able to do to your employees, the damage they might be able to do to your clients or customers. These things must also be factored in when you're deciding how involved you need to be, with a lawyer in the preparation of a contract. A few sort of easy calls for me. If you have clients, you should have a client service agreement that you use for all of them. I charge $500 usually for a client service agreement, up to $1,000 if it's more complex. But then you get to use it for all of your clients over and over again. You want to check in with your attorney once a year to make sure that there's been no new law that requires updating. But generally speaking, you can have one client service agreement and use it across the board. This not only ensures that you're getting the terms that you want as opposed to the terms that your clients might propose, but it also means that you can operate your business uniformly as to all of your clients. So that one's kind of a no-brainer, and having a form employment agreement, if you have multiple employees, is also kind of a no-brainer. You have your lawyer draft one of them. They're not that complicated. You can use them for all of your employees throughout the year. With employment law, you definitely want to check in once a year and make sure that there's no new laws that should require updating, because employment law tends to change a lot, especially in California. Other agreements that might be for a small amount of money or might be something that has to happen so fast that you don't have time to draft a formal agreement, and let's say you're willing to assume the risk. Here's a little trick. After you get off the phone, type out an email and say, hey, per our call, we agreed on the following, and go as specific as possible. Make sure you include every material term and just write out what it is that you agreed to on the phone. And then end it with, if you disagree with the above, please let me know. If I have misstated something, if I am misunderstanding anything, please let me know. Otherwise, I assume we're good to go. This is so powerful because if they don't respond, then you have their assent essentially to the agreement. I had a client that won $140,000 using this method. He detailed what the call had said, what everybody had agreed to, and then he said, if I'm wrong about anything, let me know, otherwise we're going to proceed. And then they didn't even respond to that email, but they sent another one shortly after saying, okay, I think we're good to proceed. And then later down the road, when they tried not to pay him, he pulls out the email, kind of turned the entire case on its head, actually, because he had kind of been losing up to that point. So yeah, it's a nice little trick to at least have something in writing that codifies your verbal agreement, if you're going that direction. So it's a general overview of where to allocate your contract spending to. And just to understand that every time you're doing business with anybody in any context, there is an agreement in place, whether it's oral, whether it's written, or even there's something, called course of business, that, it's the way we've been doing business this entire time, and it sort of forms its own contract. There's also quasi-contracts, right? You can draft a contract, go back and forth, negotiate it, but then you never sign it, but the terms are basically there. Or you have other things evidencing the terms like an email, right? These can all be deemed quasi-contracts. The key thing is get everything in writing, which most people seem to know now. 5 years ago, not so much, but people are pretty good about this now. Okay, so now I'm going to move on to the anatomy of a contract. Sounds so boring, I know. But if you understand some of the basics, you're going to be more empowered to advocate for yourself and to know when you really need to involve a lawyer. So key terms, obviously payment terms. Who's paying whom, when, net 10, net 15, are there late fees? Is it monthly invoice? Is it a monthly flat fee? Is it a retainer? What happens when someone disputes a payment? All of these things need to be worked into payment terms. Make sure it's as accurate as possible. The description of the services or goods. You want these to be specific enough to where you're going to know if a party breached, but not so specific that they create a rigidity that doesn't allow a party any flexibility in the way that they're performing their services or delivering their goods. So, I have a lot of clients in the marketing PR space, and they'll often have like a 2-page addendum detailing the general stages of the work that they're going to do and some of the line items that they're going to do within each stage. But they don't nail down the specifics of how they're going to do each line item and exactly what order and exactly the manner, because they need the fluidity to be able to pivot and do whatever is required for that particular client under those particular circumstances. So it's a little bit of a balancing act, but the longer you're in business, the better you'll iron that out to a point where it is more understandable and it works for you in most circumstances. I have some clients in the web development field who, because they're so detail oriented, tend to write down every single aspect of the delivery of every single product and service and blah, 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 blah. And it's so specific that it just creates a lot of problems. And so I would shy away from that and trust yourself to just have a general outline with some specifics, but nothing so specific that you're locked in. Okay. So those are obviously the terms that everybody pays the most attention to. They're the ones that their eyes fall on first. They want to make sure that they're right. But they're probably not the most important clauses. Your likely most important clauses are going to be confidentiality, limitation of liability, and indemnification. Okay, so let's just get confidentiality out of the way. If anyone's sharing confidential information with the other party, you need confidentiality terms saying, hey, you agree to keep my confidential info confidential, I agree to keep yours confidential, or if only one party is sharing, it could be unilateral. But that's critically important if there's going to be an exchange of confidential information and trade secrets. Okay, limitation of liability and indemnification. These are tough ones. Limitation of liability governs the relationship between the two parties in the contract, or the three, however many. So it says, if we sue each other, the most either one of us can get is the actual damages suffered. No one's getting punitive damages or consequential damages or anything like that that's really just deemed too unpredictable to cover. That one's an easy sell, and that one's in most contracts. The harder sell is when somebody tries to put a cap on liability. So they say, even actual damages, you can't get more than X amount. And that can be a dollar amount, like 10,000, 100,000, or it can say neither party is going to get more than the amount spent on this contract, basically. You want to be very thoughtful about these because you want to think about every different way that the relationship could go bad and what harm they could cause you, and just make sure it's accounted for. I had a client that was doing hiring a very large international bank to do their credit card processing, and at several stores around the country, and they had a limitation of liability cap at 100,000. And oh my, like if there was a data breach of all my clients' customers that had ever paid with credit card, their liability could be in the millions, right? They could be so exposed. And this bank, who was the one that was in the best position to make sure that a data breach or hack didn't occur, here they were limiting their liability to 100,000, which to them was like less than they make in like a millisecond. So they have no incentive whatsoever to actually keep. Well, they have regulatory incentive, but that's a whole other thing. There's no liability. There wasn't sufficient liability to my client in the event of a data breach. So you want to make sure that the limitation of liability is proportionate to the risk that each party has taken. And they should be mutual. I see a lot of ones propose that say, the most we'll ever have to pay you is this, but they don't limit their own, or they don't limit the other party's liability. And I think in most instances, not all, but in most instances, that's pretty unfair. I would always ask for mutuality and limitations of liability, always. There will be circumstances in which it's inappropriate, but not most of the time. Okay, indemnification. Indemnification means what happens if we get sued by outside parties. It's not about us, right? It's about third parties. So what happens if we something goes wrong in our relationship and somebody sues both of us? Who is covering whom and under what circumstance? The most common result you end up at is something like, if I breach or break the law or commit gross negligence, I'll cover you. If you breach or break the law or commit gross negligence, you'll cover me. Otherwise, we're on our own, something like that. The initial proposed clause is almost always one-sided towards the proposing party. It always says something like, you're covering me for everything that might come out of this relationship if there's a third-party lawsuit. Those are very unfair. You should push back against it. You should be very thoughtful about allocating risk in these circumstances. You need to think about how everything that could go wrong, under what circumstances it might go wrong, and who should be responsible for it. And then work that out. You're going to probably need a lawyer, though, in that case, because very few non-lawyers understand indemnification, and a lot of lawyers I have found don't fully understand indemnification as well. So make sure you have a good lawyer. Okay. Aside from those clauses, what we're really left dealing with are boilerplate clauses. Those are the clauses that are at the end of every agreement, right? And they may seem like they're generic and they're not important, but some of them are very important. You want a severability clause in every contract, which says, like, if anything in this contract is deemed to be illegal or unenforceable, the rest of the contract stands. You want something saying, a modification clause saying nobody can modify this except with mutual assent of the parties. You want something that says this is a fully integrated contract, meaning this is the whole agreement. There's no outside agreement aside from what's written here on the paper. You probably want a good notices clause. Dispute resolution is a great thing to address. I love pre-litigation mediation requirements, meaning, hey, if we have a fight about something, before one of us can rush to the courthouse, we have to spend an afternoon together in a room with a neutral third party and each tell our side, and they'll try to help us work it out. It's not binding, but it really does resolve a lot of disputes before you start incurring legal fees. So I love those, putting mediation in every contract. And then you decide whether to put arbitration in there. Arbitration is like private court. You have to pay the judge, so it can be more expensive to file, but it tends to get resolved much faster than court, and it's confidential. So you have to weigh, I might have to spend a lot of money to initiate the claim, but probably through the life of the claim, it's going to end up costing me less. probably, not always, probably. And it's going to be more confidential because it's not going to be publicly filed. So carefully consider that. You should probably talk to a lawyer if you're contemplating an arbitration clause as well to make sure that it's right for you. Arbitration is not appealable, and arbitrators do get it wrong, and you're stuck with it if they get it wrong. So that's a huge drawback. They also give smaller awards, which is good if you're the party that's more likely to get sued. It's great. But if you're the party more likely to need to sue the other party, you might want to rethink having an arbitration clause. So that's it. That's the general basic anatomy of most contracts. I didn't cover everything, but I hopefully covered enough to where you have a general understanding of the way that they work, what's important, and when to involve an attorney. They're not rocket scientists, but they don't require a rocket scientist, but they're a lot more complicated than people think. People think because this contract is written in plain English and I understand what it says, that I understand the implications. But that is absolutely often not the case, because there are contract terms that are just prohibited by law, like non-competes in California. There are contract terms that don't mean exactly what they say they mean. They have an additional meaning that's sort of baked into common law, right? So there's so many different ways that an agreement can go wrong. And if a relationship is important or has a potential to financially damage you, get a lawyer. Otherwise, put everything in writing. Emails are great. They're not as good as written contracts, but they're a whole lot better than verbal agreements. Thanks.